taken on respondent number 5 so that he appears this time. But unfortunately, the counsel who was associated with this particular writ appeal has passed away. So although order has been passed on 12 to 2018, no fresh steps has been taken on respondent number 5 till date, Your Lordship.
12 to 2018.
18, Your Lordship.
I don't have that order. We have the order.
No.
There's no order of 12 to 2018.
It was an order
Are you sure it's an order of 12 to 2018?
before concern our joint register vigilance.
Oh, huh?
Order was,
Lawazima Court.
yes, Lordship.
No, respondent number 5, you need not worry because Mr. Mojumdar is there. If he is there, he'll take up. 6, notice served.
Yes,
So you
Your
can proceed with the hearing. 5, if it does not come, if there is something, then
Yes.
they will face the thing. There is nothing against. You can proceed with the hearing.
We have gone through the records of writ petition, Your Lordship. Then also respondent number 5, who is the custodian of all the office documents and records, has not been submitted. We couldn't peruse the original documents.
That's not your prayer before the writ court. The writ court has come to a conclusion.
Yes.
The first and foremost underlying factor is that you were purportedly appointed in 2000,
Yes.
right?
Yes.
But you yourself admit that you passed your matriculation in 2007.
Yes.
So the appointment from that period from 2005 to 2007, even if we hold that you were appointed, is of no consequence because that's contrary to all norms requisite for. And you couldn't show anything on record that there was a relaxation made in your favor.
Yes.
So in that light of the matter, forget respondent number 6. Establish your right. Convince this this court that because for these reasons I should be up. And we can then consider the issue. Why don't you start off with the hearing?
Yes, Your Lordship, as I have passed matriculation on 2007, that was my that was my minus point in regarding appointment. That the case is that I was asked to join the school, although there is no written document, because it is a very remote school. It is a very remote school in a tea garden, and I belong to the same community. I was asked to serve in the school. In venture schools, it happens, Your Lordship, that in a remote school, no educated person, nobody is interested to work there. So I was asked, I was studying at that time, and I was teaching the children also. They are very poor children from the labor community. They were there in the school. I was teaching them. I was doing my job. Yes, it is true that there is no written document that my educational qualification was relaxed, but it was the fact that I have been serving. And my name is reflected in the DIAS 2009 and 10, in the DIAS 2010 and 11, and in the DIAS 2011 and 12. In all 3 consecutive years, my name has been reflected. If I was not eligible to serve in the post, then why my name was reflected in DIAS 2009 and 10? That should not be there. It should not be. It should have been omitted. If my name is there, it is a proof that I have been serving. I have passed my matriculation in 2007. Okay, if my appointment from 2005 is not considered, then from 2007 at least it should be considered, because in 2009, 10, 10, 11 and 11, 12, my name has been reflected in DIAS. I was legally serving in that post. And the DIAS documents are the proofs. But all of a sudden, my name has been omitted. And for when it was sent for provincialization, my name has been omitted. And someone else, the respondent number 6, her name has been reflected. In DIAS 2011 and 12, her name was reflected in serial number 3. My name was reflected in serial number 2. It means that I was senior to her. if my educational qualifications in the year 2005 is not considered, I have passed matriculation in 2007, and in 2007, if I have passed, if it is considered from that year also, then the respondent number 6 is junior to me, according to the Dais records, Your Lordship.
Okay.
And Dais records are official documents. I cannot tamper the Dais records. I am not the custodian of the Dais records. If it is somehow tempered also, it is tempered by respondent number 5 only, because he is the headmaster, he is the custodian of all the Dais records. The Dais clearly reflects my legal appointment. And Dais, it clearly reflects that some anomalies are there at the time of provincialization of the school to omit my name and regularize the appointment of respondent number 6, Your Lordship.
Then in the writ petition, did you challenge this order, page 96?
We have filed the writ petition before the order has been passed, Your Lordship. When I came to know from all the official sources that my name has not been sent for provincialization, then I filed this writ petition. After that, the order has been passed, Your Lordship. Provincialization order has been passed.
Pendency of the writ petition,
Pendency of writ petition.
then you could have challenged that again.
Yes,
That you could have challenged.
yes.
You didn't.
That was not done, Your Lordship. After, during pendency of the writ petition, that provincialization order has been passed, and that provincialization order was should have been challenged by filing one IA or but that was not done in during the writ petition, Your Lordship.
So what is left now?
Lordship, during passing the order in the writ petition, many other anomalies are also there. That no action has been taken against respondent number 5 also, because so many complaints are there. No action has been taken on respondent number 5, and that order has been passed. Order was passed during pendency of the writ petition. It was a fault on the part of me for not challenging that order. But that the anomalies are very clear from the records, Your Lordship. In the face of the records, the anomalies are very clear.
Can you point out those anomalies? Can you point out those anomalies? Just Mr. Muzumdar, what is the minimum qualification in 2005 to 2007 period for a LP school teacher?
Matriculation. Matriculation.
Please. The anomalies. Why don't you start the case in the manner you require? We have been troubling you. You start off arguing the matter in the manner you require,
Yes, Your Lordship.
along with the facts.
Yes. In the 2005 to 2007, the school was venture. I was appointed by the president of the managing committee, and my educational qualification was not considered at that moment. I was a student. And I was preparing for appearing of my matriculation examination, which I have passed in the year 2007. And since 2007 also, if that period 2005 to 7 is not considered, if it is considered that after passing my matriculation, I am in the service in the Dais in 2009 and 10 and 10 and 11 and 11, 12, my name has been reflected. When in 2010 and 11 and 11 and 12, there were overwriting in the Dais records and that was pointed out by the learned single judge while judging the writ petition. But your lordship, those overwritings and all cannot be made by me because I am not the custodian of all those records. So it is clear from all those overwritings and all in the dais records that some anomalies are there, that the respondent number 5 might have done some anomalies to discard my right and to give
Madam,
opportunity
Madam,
to respondent number 6.
Take us to those facts in the records. You're making an oral submission, kindly show from the records.
Yes.
Here,
The
where
anomalies.
those things have been reflected. In the order or in the documents, what you're trying to submit, where is it reflected? Can you
Yes.
just point out?
Yes, your lordship.
You can start from, if required, the conclusions are from page 81. There are 10 point. Conclusions of the honorable Supreme Court.
Lordship,
You're not prepared?
Lordship, I'm a little prepared,
Fully prepared.
not fully, because I thought that this notices will have to be served upon respondent number 5.
That is too late in the day. If you want time, we can give you time for your preparation, but we will proceed.
One more date may be considered, your lordship, for hearing.
We can give her a date. This week,
Yes, your lordship.
your good name
J.D. Khound.
on request made by Ms. J.D. Khan and also for the applicant. List down, when do you want? Thursday?
Thursday, what do I say? Oblige, your lordship. Thursday.
Thursday is what, 16? 16.
Item number 16 and 17, lordship, kindly date may be fixed because GN Saval and KN Chodisar is another court. It is very fast. That's
Somebody
when
had
date may-
mentioned.
This was mentioned on the request of Mr. Babujari report.
Borpujari is bereavement.
Oh, that the report?
Oh,
Okay.
he's in bereavement.
Report,
Oh,
that is why.
so after any date may after 2 weeks, lordship, that convenient to
It
that.
was said 3 weeks isn't it?
3 weeks.
On request of Mayor Babujari.
Like,
Kindly fix on 17, your lordship.
It is not a hearing day. 17 is not a hearing day.
Okay. Can I, lordship, 20?
21st.
Okay. Much obliged, your lordship.
মানে দুসপ্তাহটো ধৰক হেৰি হোৱালৈকে শ্ৰাদ্ধ ভোজলৈকে নাহেই তাৰপিছত আৰু 3 দিন দি দিয়ক না 21 দিনৰ পিছত হ'লে
My lordships, with due respect, I could not get a few books. So I have the names though. I would like to lead an argument to say that so far as the petitioner is concerned, the Assam Services Pension Rules 1969 is applicable, and the way they are breeding in the CCS rules would not be applicable. That is one limb of argument. If minority is pleased to hold no, otherwise CCS pension rules is applicable, then I will go to attempt to interpret Rule 7. May I start? In the meantime, I'll get the books. May I just read it out? What I'm
Your books are not ready?
No, they will be. I just indicate briefly what the things are. My lord, the dates. The State of Nagaland Act 1962 comes into force on 1/1/1963. Now, the territories in which the Act applies comes into force. The Naga Hills, Suensang areas of the state of Assam. So the Act comes into force. Now, so far as the conditions of services of the persons under this is concerned, the government of Nagaland, the Assam Act is applicable at that stage. Now, so far as the writ petitioner is concerned, since she was appointed in the year 1967 and the Act came in 1/1/63, therefore, in the state of Nagaland, for the pay structure, pay conditions, everything, the Acts of Assam and the FRSR was applicable at that point of time, 67. Now, since under the state of Assam, the Act which will be applicable to the petitioner is the Assam Secondary Education Act 1961, which was prevalent as of 1961 to 67. Now, the Assam Secondary Education Provisionalization Act 1977 comes into play under that. Under Section 3, petitioner becomes a government servant. As in Nagaland, but the Act of Assam would be applicable. Since it's applicable, under the Education Act, the petitioner becomes a government servant under Section 3. Now, so the petitioner is entitled to pension in accordance with the pension rules applicable to the state of Assam, as in the timeline. I'm coming to that. Now, the Assam Technical Education Service Rules, 1981. This is there. Under it, service means Assam Technical Education Service. Rule 3 gives class and cadre. Rule 3.1, whatever it is, says class 1 service consists of, amongst others, lecturer of engineering college. Now, REC Silchar, as in the year 1984, was funded by the state government and board. So, the 1981 Act applied. This 81 Act, Assam Technical Service Education Rules, Service Rules 81, this applied to the petition as well. Because the service in the engineering college was covered under this Act. And Nagaland, since it formed the state in 61, the entire things, the Acts of Assam were applicable. Moving forward, all matters relating to pay, allowances, leave, pension, discipline, etc. were under the rules in Assam, as in there. So, the Assam Services Pension Rules 1969 would apply to the petitioner in Nagaland by virtue of Section 3(4) of the Assam Secondary Education Provisionalization Act 1967. And
Mr. Banik, are you going on the right track?
maybe, what I'm trying to develop is that so far as the writ petitioner is concerned, there are two limbs of argument. One day I argue the 7(2) is not applicable. We'll go to that. But if this limb of argument is considered, maybe if Lordship considers in the perspective I'm trying to put it, that the applicability of two rules of Assam in the timeline would make the Assam Services Pension Rules 1960.
What rules? Where are the rules?
Well, Assam Services, that I could just get the things, need some time to get the books. That's what.
Then we'll fix tomorrow.
Lordship.
Tomorrow.
Tomorrow is 15. Yes, Lordship, tomorrow.
Tomorrow I'm having some difficulty. Can it be on Thursday?
Thursday, 16. 16 na like. 16
All
August.
on one point, law. So this is a re-employed pensioner or not?
So we are trying.
That is the thing to be adjudicated by this novel court.
Then I'll go to the first, I'll leave it for the present. If need
No,
be,
give your date, give your date.
if Lordship, if I address on the re-employment part on
That's
the,
why I want to see all those things.
but the two parts of the argument,
Yeah.
could it be on, the November
Month of December.
20th or 21st? 21st is a Tuesday,
21st.
21st?
Okay, on request.
21st.
There is Bunny Kalanda Council. List on 21st.
May I give a write-up of this thing or what?
Yeah, let's see, but I don't think that's.
There are two lines of argument,
Anyway, since you want to argue that matter.
That's not business. I want to keep it a part of record. That's
Bring
what,
the books,
Lordship.
serve copies.
Yes,
of
I'll
the
let
other
him,
side.
I'll let him.
Okay, on request, met on behalf of S. Jahan and the additional. List the matter again on 21st.